I am sentencing Reddit user Throwaway for Weed 666 to the internet court for drugging their family. We are not debating whether THC is legal in Canada. It is. What we're examining is judgment. The defendant knowingly baked THC-infused brownies and hid them in her bedroom closet while hosting her visiting mother. She left the home. While she was gone, her mother and sister consumed those brownies and were later found on her couch barely blinking, watching a Korean show without subtitles, completely incapacitated. Her response: water, a blanket, bedtime. She claims she did nothing wrong. The court will determine whether this was innocent oversight or reckless edible negligence.
Okay.
Your client prepared psychoactive substances in edible form and left them accessible in a home where guests were present. If a person knowingly creates a drug-laced product and others ingest it without informed consent, how is that not, at minimum, reckless drugging?
Let's slow this down for a minute. My client, in her own home, used a product in which was legal in her area of residence. She's had visitors come into the home in which have gone into her private areas and uncovered things in which had been hidden from them, and they have stolen from her. They have robbed her. And at the end of the day, my client's the victim here, because now she has to make more brownies.
Okay. Second statement. Your client admits she knew her mother was visiting. She admits the brownies were infused with THC. She chose to leave them in the house. When those brownies were consumed and her family was incapacitated, she did not seek medical attention. Are you asking the court to believe she has no responsibility in what amounts to her family being unknowingly drugged?
At the end of the day, I think people need to take responsibility for their actions. I wholeheartedly believe that. So, I think the mother and the rest of the family members in which had robbed my client of her own personal products from which it legally she is entitled to have, they should be responsible for their own care. They robbed my client, and if anything, they should be baking her more brownies in reparations.
Interesting.
Thieves. Absolute thieves. My client has done nothing here. Free my mans.
Order.
Free my mans.
Okay. Statement number 3. Edibles are indistinguishable from normal baked goods. They look the same, they smell the same. They are by design meant to be eaten. If your client did not clearly label or secure them, knowing other people were in the house, wasn't it entirely foreseeable that someone would consume them? And if it was foreseeable, how is this not negligent drugging?
Well, it's not negligent drugging because she didn't give them the brownies. This isn't Fort Knox we're talking about. We're talking about a private domicile, a home. She had hidden stuff in her own personal bedroom, in her own home, and you're coming to me right now and accusing my client of drugging people when she wasn't even there. They went into her room and stole the baked goods. It doesn't matter what was in the baked goods, they were stolen, and it just doesn't matter. At the end of the day, they robbed my client. My client deserves either some fresh dank, some of that 1010 good yayo, or my client deserves some free buds in return for this. This is outrageous. She has been robbed blind. She literally was blind. She could not be there. She did not see this. She went out of her way to ensure the secure detainment of the products. This isn't Fort Knox. What, is she meant to get an isolation chamber to put her brownies in? Just so that someone doesn't rob her. This is outrageous, and this case needs to be dropped immediately. I rest my case.
Okay. So, how do you declare your client?
Not guilty.
Based on the lawyer's rebuttal, I think his statements are completely valid, and I hereby rest this case by saying the client is not guilty.
Dubs in the chat.